Hi, I'm John Cannon with Cannon Associates, your fierce advocate. And in this video today, I'm going to be walking you through the 7 major differences between the prosecution of a sexual assault case and a civil lawsuit for sexual assault. The first major difference is the burden of proof. The burden of proof is what the party must prove in order to prevail in a case. In a criminal prosecution, the prosecutor has the burden to prove beyond a reasonable doubt, the highest burden in our justice system, that the defendant committed the alleged sexual assault. In a civil case, the burden of proof is preponderance of the evidence, more likely than not, or 51%, that the defendant committed the alleged sexual assault. The second major difference between a civil case and criminal prosecution for sexual assault is the penalties. In a criminal case, the defendant can face substantial prison time, difficult terms of probation, sex offender registration, and other costs and difficulties through their criminal case. Alternatively, in a civil case, the penalties are damages, both non-economic and economic damages, things that have been suffered as out-of-pocket expenses and future expenses to the victim in the case. The third major difference between a civil case and a criminal case for sexual assault is the right to counsel. The defendant in a criminal prosecution has the right to counsel. They cannot afford to retain their own counsel, then they are entitled to seek or request appointed counsel from the court. Alternatively, in a civil lawsuit, you are not entitled to counsel. It is important to retain counsel if you are facing a sexual assault lawsuit. However, you must come up with the means to retain counsel yourself. Conversely, the plaintiff in a sexual assault case, it's very important that you retain counsel to help you fight for your rights and damages in your case. The fourth major difference is the parties, or the who. In a criminal prosecution, the two major parties are one, the state that is prosecuting the case through the prosecutor, and the defendant, the criminal alleged, who is facing the charges of sexual assault. You did not hear me say the victim in the case because they're not actually a party in the criminal case. They are a necessary witness and they play a major role in the prosecution, but you are not a party to the criminal case as the victim of a sexual assault. Alternatively, in a civil lawsuit, you are the primary party. The plaintiff in a sexual assault case is the victim bringing the charges and allegations against the defendant. Multiple causes of action can be sought by the plaintiff in a sexual assault case, and they can be brought not only against the perpetrator of the sexual assault, but they can also be raised against parties that may have enabled or played a role in that sexual assault happening. The fifth major difference in the prosecution or civil lawsuit for sexual assault is the right to bring claims, the if. In a criminal case, the prosecutor is the one that decides whether charges will be filed and what those charges will be. Contrary to common belief, the victim plays a role in identifying the claims, but does not have decision authority in whether charges will be brought. Alternatively, in a civil case, you as the plaintiff play a major role in that decision factor. With the assistance of an experienced plaintiff's attorney, you will decide what causes of action to bring and who those causes of action will be brought against. The sixth major difference between criminal prosecution and a civil lawsuit for sexual assault is the what charges will be brought. In the district attorney or the U.S. Attorney's Office, they elect what criminal charges will be filed against the defendant. Those decisions are largely based on the facts or allegations compared to the criminal statutes at play, such as rape, sodomy, sexual battery, unwanted contact, and other criminal charges of the like. Alternatively, in a civil lawsuit, you, with the assistance of your plaintiff's attorney, will decide what charges you will bring, whether those are battery, assault, intentional infliction of emotional distress, or a variety of other allegations that can be brought against the perpetrator or a party that contributed to allowing the assault to take place. The seventh and final factor that differentiates between criminal sexual assault case and a sexual assault lawsuit is the statute of limitations, or the when. The statute of limitations dictates when a party can bring a cause of action after the events take place. The default in Oklahoma for sexual assault felony cases is 7 years, meaning that from the date that the sexual assault took place to the date that the charges are brought cannot be any longer than 7 years for the state to seek charges. Alternatively, in a civil case, the limit for the bringing of a lawsuit is typically 2 years, meaning from the date that the alleged sexual assault took place to the date that the lawsuit is filed cannot be any longer than 2 years, or you may lose your right to bring the lawsuit forever. We're one of the few law firms in the state of Oklahoma that handles sexual assault lawsuits on behalf of plaintiffs. If you have questions about these issues, or feel that you or a loved one may be the victim of a sexual assault, please visit our website, www.jpcannonlawfirm.com, for questions answered, videos, and other resources to help you through this process. You also will find a contact box on every page of our website that you may fill out, and one of our team members will follow up with you. For immediate assistance, please feel free to call us 24 hours a day at 405-657-2323. We look forward to being your fierce advocate.